Good morning. Number one, the judgment will help you to understand how documents which were not properly valued as per Indian Stamp Act has to be treated by the court, which all are the authorities. Then question arises during the arbitration proceedings, if such is pleaded that the agreement or some document which was placed before the arbitrator is not properly stamped, whether arbitrator can act upon as per Indian Stamp Act section 33 and 35 of the Indian Stamp Act. Then there was earlier some judgments, and finally Supreme Court AR 2024-1 AR 2024-1 curative petition in interplay between arbitration agreement under the Arbitration and Conciliation Act and the Indian Stamp Act was delivered, and you have to go seven judges judgment headed by Chief Justice Dhananjaya Y. Chandrachud. This judgment may enlighten you so many aspects, including interpretations, what not they are about up to V up to V X Y Z. So out of 26 alphabet, 3 were not there. Therefore 23 para index were scheduled. Every index that in the period to judgment is very important if a person wants to prepare for judge's judgment. So many things have been discussed here. Actually, what had happened, you have to, I will go through the narration. They say reference, it was references about the maintainability of Indian Stamp Act, and that was decided the competence to competence. That was Numo Juda Casa. Numo Juda Casa means a person or authority cannot sit as a judge if he involves in that for his own cause. Numo Juda Casa. Here, in Arbitration and Conciliation Act, arbitrator is permitted to decide his competency if suppose any objection was there. So competence to competence has been given. That way the Supreme Court 7 full judgment says it is international law, approved international law, that is competence to competency act. Here then they have discussed a multi number of times about Indian Stamp Act, wherein they have clearly stated that section 35 gives who are the authority to impound the document. That is what they say. This is what they say. Intervention at the stage of application, claiming that a certified copy of the agreement discloses non-payment of stamp duty. So whether the court can, whether the arbitrator may be permitted to decide that issue also, it was deeply discussed. So you must be very careful in reading every paragraph, every this index in the judgment up to B, that is 23. Everywhere they are deeply discussed about the limitation. They say under section 35, since any authority receiving any document to decide the issue on consent. So that shows that conciliation proceedings and this mediation proceedings and arbitration proceedings, those authorities can decide this issue of stamp. That is was the verdict, I understand. And the state Stamp Act is a fiscal law. They say fiscal law. They say extent of judicial intervention in the arbitral process should be bare minimum. That was because international law wants for proper commercialization resolve. Dispute resolution should be in a proper way. There may not be any as normal adjudicatory process wherein a court normally intervenes. Then they say the foundation of arbitration is consent of parties to submit their dispute to arbitration. Then doctrine of competence and competence, they have discussed it. Then at index N, they say competence to competence, positive and negative aspect. So this is most important to answer if the question is asked. Be careful about this. They say first to recognize mutual intention of parties choosing the arbitration to resolve all their disputes about substantive rights and obligations arising out of the contract. Second, to prevent parties from initiating parallel proceedings before courts and delaying the arbitral process. So that is for positive. The negative aspect says it speaks to national court. It instructs the court to limit their interference at the referral stage by deferring to the jurisdiction of arbitral tribunal in issues pertaining to the existence and validity of arbitration agreement. So these things has to be understood. Then they say at O, arbitral tribunal is an authority is wide enough to comprehend all preliminary issues affecting its jurisdiction, including the issue of sufficiency of stamping. So most important things, you have to follow it. I do not want to bore you. Then they say that interpretation of statutes, harmonious construction. Harmonious constructions means that is workable for both acts, Arbitration Act as well as Stamp Act. It should be interpreted harmoniously. Then harmoniously means intention of the legislation which was passed to decide the issues. Then arbitration agreement, precondition of stamping necessity. They say section 11(6)(a) of the Arbitration Act requires the court to confine itself to the examination of existence of arbitration agreement. This provision stands in contrast with section 33(2) of the Stamp Act, which also used the words examine. 33(2) requires the person before whom an instrument is produced to examine whether it is stamped with the stamp of the value and description required by the law when such instrument was executed or first executed. So this is also most important. Then say competence doctrine, nature of objection, issues which concern the payment of stamp duty shall fall within the ambit of arbitration tribunal. Such a extraordinary judgment you have to understand. See, they say as cross-border commerce and transaction proliferated, companies and business sought different ways to resolve their commercial dispute. Formally, customs and legal tradition of national courts were at variance with the intention of parties to achieve a speedy and efficient resolution of their dispute. Therefore, Arbitration Act was enacted. They say unilateral model law. New York Convention made unilateral model law. So, if you go through the earlier, there was an Arbitration Act as well as Conciliation Act. That has 1940. Then this act has been 1996. Arbitration Conciliation Act was enacted, and we have no other way because our Narasimha Rao has accepted for GATT agreement, General Agreement for tax and tariff. So thereafter there is no other way. Best wishes.